Good afternoon, everybody, and nice to be here. I must thank the GCAI for having conceptualized this program of inviting students from different parts of the country. I believe all of you have had the privilege of going to Parliament and of doing other things other than just lectures in classrooms. I'm glad that I heard partly my good friend Arun here, and when we were discussing what is the topic I was going to take, I thought I'll deal with the 7th schedule, because when we talk of the Constitution, I believe you've already been given a primer on what the Constitution is, know your Constitution and so on, but I'll just deal with Schedule 7. Now, as you know, the Constitution of India, and 7 is basically distribution of legislative power, what Parliament can do, what states can do, and what concurrently both Parliament and state can do. See, in the Government of India Act 1935, when they had the federal government and they had the provincial government, there was a necessity to divide the legislative power. And there are certain powers which the federal government could utilize and Parliament can take. These are basically issues which affect the country at large, very important national events, like, for example, defense, telecommunications, like posts and telegraphs. These are all matters which come under the union list. They came under the federal list. Now they came under the union list, where Parliament has the exclusive power to legislate. Similarly, you have subjects which differ from state to state. And that's where Parliament, our Constitution has decided to divide them and give it them to the states. For example, agriculture, right? Then you have industries other than declared industries. So you have various entries in the state list where only state governments can legislate. And then you have the concurrent list, where the concurrent list, both Parliament and state legislatures can legislate. What happens in a conflict, I'll come to shortly. But for your purpose, by the way, before I start, how many of you have already studied constitutional law? Anybody? Can you just raise your hands? Oh, good. So I can go at a much faster pace. You all have seen the 7th schedule, haven't you? Yes. All of you seen the 7th. So that makes it easy for me. And this 7th schedule, the division of powers, is basically taken from the Canadian and Australian Constitution. There also, certain powers are given to the federal government, certain powers are given to the state government. The difference in Canada and Australia is that there, whatever is not given to the center or the federal government is automatically given to the states. In India, it is just the opposite. Entry 97 says that if some matter is not mentioned in list 1 or list 2, it automatically goes to the union list under entry what? You studied the Constitution, now tell me. Entry 97 of list 1 is the residuary entry. So, for example, when they came to levy gift tax, entry 82 list 1 talks of tax on income. There is no reference to gift tax. So when they levied gift tax, and it was challenged before the Supreme Court, they said that when X gifted his agricultural property to Y, they sought to levy gift tax on him. So the question was, Parliament is not competent to levy gift tax because gift tax is not mentioned at all. Parliament said no. The Supreme Court said no. Whatever is not mentioned in list 1 and list 2 automatically falls under entry 97 of list 1. So gift tax was upheld as being coming under the residuary power of the Constitution. More important and more larger in terms of revenue is the service tax. Right? The service tax was recommended by Raja Chalaya committee. He said, look, in the economy, goods and services are the two major components of the economy. You have tax on goods, you have excise duty on manufacture, you have sales tax on sales. But as a lawyer, as a chartered accountant, as a as a management consultant, right, there is no tax on your services. So he recommended that the service sector of the economy is going untaxed. There's a scope for augmenting revenue, increasing revenue by levying tax on services. Then the question arose, where is the power to levy service tax? There is no tax on service anywhere. Go back to entry 97 of list 1. So Finance Act 1994 levied was justified under entry 97. There is a small twist to it. They did introduce 92C of the Constitution, called it tax on service, but they never brought it into force. Right? The amendment was made, the 88th amendment brought into force 92C, but never brought it into force. My hunch or my reasoning is that if they had brought it into force, the center would have to share 41% of the service tax revenue with the states. Perhaps they didn't want to do it, so they kept a service tax under entry 97. Entry 92C, introduced by the 88th amendment, never saw the light of the day. It came into force, it came into the constitution, and when the GST came, the 101st amendment deleted that. So now you got goods and services tax, which comes under 246A. I'll come to that shortly. So therefore you have a division of power. One important point is wherever the power is not mentioned, Parliament always has the residuary power to levy the tax. Parliament can do it. Significantly, states have no residuary power. States cannot do anything which is not provided in list 2. Right? So very interesting question came. Rajagopalachari, the first Governor General of India, he was the Chief Minister of Madras, the then Madras Presidency, Madras. He was, in fact, Madras General Sales Tax was the first sales tax in the country. Now, every government wants endless amount of money. It's never enough. So, Rajaji's government thought, why don't we levy sales tax on works contract, right? Now, sales tax, entry 54 of list 2, you can levy sales tax on sale of goods. Any state government can levy purchase tax or sales tax on the sale or purchase of goods, no problem. Now, what did the Tamil Nadu, then Madras government do? They said sale means and includes transfer of property for consideration, etc., comma, and includes works contract. So the definition of sale was expanded to include works contract. Now, a landmark judgment, Gannon Dunkley, they went into the scope of the whole provision. They said, look, state government, you can levy tax on sale. Sale is not defined in the constitution. Now, what is sale? Can you tell me what are the ingredients of a sale? Can you tell me? When do you say sale of goods takes place? What are the ingredients? Yeah, tell me. Sale. No, that's a contract. What are the ingredients of a sale? Seller and buyer, yes. Anything else? Transfer of goods, correct. So there should be seller and buyer. There should be consideration in money, because if it's not in money, it becomes an exchange, comes under 118 of the Transfer of Property Act. So you're right. So sale will involve a seller and a buyer. Consideration is in money. What is transferred are goods. And the seller ceases to be the owner and the buyer becomes the owner of the goods. Now in a works contract, where is the seller, where is the buyer? There is nothing. I engage a contractor to build my house. He takes cement, steel, etc., constructs the house. It's a works contract. I pay him contract charges. I engage a tailor to make a shirt for me or a trouser for me. Works contract. So, very important. What the Supreme Court held, actually Madras High Court held, and then Supreme Court confirmed. They said states have the power to tax sale. They can only tax what is a sale. They cannot amend their law and bring into something which is not a sale. So the landmark provision is, since states don't have entry 97, you are limited by what is used in the list 2. Now sale is not defined, but the court said, although sale may not define, is not defined, it is nomen juris. You can make a note, it is nomen juris. It has got a particular juristic connotation. Sale, as all of you rightly said, seller, buyer, goods, money. So they said, in a works contract, there is no seller, there is no buyer. They cannot be transfer of property and goods. And they struck down the Madras legislation saying, states cannot, this is very important, states cannot expand their powers by giving artificial definition to sale. Now, this is not only important in tax, even in terms of ordinary other things also, sale can't. For example, states have got power of agriculture. Now, they can't include non-agricultural activities and try to legislate on that. So, what you should remember is, as far as Parliament is concerned, anything which is not mentioned in list 1 or list 2 will automatically come in entry 97. But as far as states are concerned, they are limited by the scope of list 1 and list 2. So this is the first part. Now, let us go to the architecture. One more thing I'll tell you. We have got a very elaborate concurrent list. So if my memory serves me right, Canada has just got 2 items on the concurrent list. One is immigration and one more thing I can't recollect now. Only 2 things are in the concurrent list. Everything is either in the federal list or in the provincial list. But we have got a very elaborate concurrent list. Now let us go to the architecture of these lists, how it has been divided. Very fascinating, very beautifully done. You can make a note that every list, that is list 1 and list 2, not list 3, list 1 and list 2, there are general entries and there are taxing entries. Right? If you go to list 1, list entry 1 to 81 are general entries, 82 onwards are taxing entries. So you will have general entries, telecommunication, defense, railways, high seas fishing, all these things are coming under the general entries. Then when you come to tax, you got specific taxation provisions. 82 is tax on income, 83 is tax on customs, 84 is excise duty, and so on and so forth. So these are all taxes. And of course you have entry 97. Similarly, in list 2, 1 to 44 are general entries, then you start getting all the taxing entries, 46 is agricultural income and so on and so forth. This is how the entries goes. And at the end of list 1 and list 2, you have general entries for levying cess and stamp duties. So whatever is mentioned in list 1, Parliament can levy cess. Whatever is mentioned in list 2, the state government can levy a cess. So they can levy agricultural cess. Suppose they got some betting and gambling, they can levy a betting cess. Anything concerned with that, they can levy a cess on that also. Now, we are coming to a very interesting question which is pending before the Supreme Court now. Must have all heard of online gaming, right? Now, Parliament has passed a law. It has not yet been notified. They have passed the law banning online games for consideration. You can play online games without consideration, but that nobody's interested. I mean, yeah. It's like saying I'll go to a bar and have Horlicks or something like that. It's as absurd as that. Yeah. So, now we have raised a question. Betting and gambling is coming under entry 33 of list 2. Right? Can Parliament ban betting and gambling? Because if betting and gambling is a state subject, we have taken the contention that Parliament has no power to. What Parliament's stand is, we are not touching betting and gambling. Online game is done through electronics. Electronics and telecommunications entry 31 of list 1. So we are basically prohibiting the use of telecommunications and online systems for the revenue. So ultimately the court will decide. This is the position. But I'll tell you an interesting story. There is a peculiar provision called Article 252, where whatever is in the state list, states can request the central government to pass a law. You know, in 1952-53, there was there was a prize competitions act. Crossword puzzles and prize competitions were there, on which you place a bet, you enter the thing and you get a prize. I'm not getting into games of skill, games on chance and so on. But many states said that, look, if I ban a thing in Madras, the person can start playing from Bombay. If I ban a thing in then Mysore state, I can play it in Andhra Pradesh. So it doesn't work. So many states got together and requested the court to pass the Prize Competitions Act 1955. So one stand we have taken is, this Betting and Gambling Act of 2025 is bad. If you wanted to ban it, individual states should have got together. There only about 11 states got together and said, please ban prize competitions. Right? And the Supreme Court upheld that, but they said that if it's a game of chance, it is not betting and gambling. If it's a game of skill, then it's not betting and gambling. If it's a game of chance, then only there is betting. So they said that the Prize Competitions Act a game of skill, if you want to, I know my friends, sons, etc., who are professional poker players. Tomorrow, if you want to play a game of skill, you want to play poker, you want to play rummy, you want to play bridge as a profession and earn money, it's a game of skill. It is protected by Article 19(1)(g), right to carry on business. That's what the Supreme Court said. So they said games of skill can't be banned. And that judgment, R.M.D. Chamarbagwala, is an important judgment for what is a game of skill, what's a game of chance. And they said game of skill is covered by Article 19(1)(g). You cannot ban it completely, right? It's a fundamental right. So that's it. So now I've coming to this position of I mentioned about the architecture. There are general entries and there are taxing entries. Now, what is the other difficulty in List 7? Now, very interestingly, List 7 gives rise to several interesting controversies. And I'll just take 3 of them for shortage of time. One is called the Doctrine of Pith and Substance. Right? You must have heard of Pith and Substance. Have all of you been taught occupied field? Doctrine of occupied field? Then Doctrine of Colorable legislation? Yes. Occupied field? Yes. I'll deal with each of them. Now take Pith and Substance. What is the Doctrine of Pith and Substance? Please take the trouble of reading the recent judgment in mining and development, the MADA judgment, which deals mining and minerals. There, Justice Chandrachud has elaborately discussed the scope of Schedule 7. What are the entries? What is colorable legislation? What is Pith and Substance? What is occupied field? In one judgment, you will get a complete picture of the law on the subject, very exhaustively and very elaborately done. Now, take Pith and Substance. I just got some new judgments. I noted for your paper. I thought instead of dealing with many cases, I'll just keep a few of them. Yes. What is Pith and Substance? Pith and substance means take a law, you try to understand the true nature and character of a law. The pith and substance of the act is what is the real nature and what is the real character of the act. Now, a law may appear to be under list 1, but actually will be under list 2. I'll give a very interesting example. I took a latest judgment. There is a company which has got tea estates. Now, income from sale of tea is agricultural income, right? So, if anybody has tea estates, the tea estates will be normally subject to state agriculture tax. So, whatever the income from tea is there, it will be subject to state tax. Now, let us say you own shares in Tata Tea. Right? Tata Tea has got tea estates, got coffee estates. That company declares dividends. Now, the person argued that if I have got shares in a company having agricultural income and that company declares dividend, that dividend income is nothing but agricultural income. Where did the money of Tata Tea come from? Agriculture. So the declaration of dividend is nothing but agricultural income. But the court said no. Once the money is earned by the company, it becomes company profits. Whatever may be the source, you may get money from liquor. That doesn't mean it is liquor profits. It is company profits. So once the tea income comes to the company and the company then declares dividend, then they said dividend will be subject to income tax, not to agricultural income tax. Why? Because 115O was held to be in pith and substance a tax on income, dividend income, and not a tax on agricultural income. So the dividend tax under the Income Tax Act is in pith and substance a tax on the dividends distributed by a company to its shareholders. It is not agricultural income. The moment the money enters into the company and then is distributed, it no longer has the characteristic of a agricultural income. That is one example of thing. Now, take for example a very famous case. Now, you know, many people, they've got this agricultural write-off. For farmers, they write off agricultural loans. Now, one person said that you can't write off these loans because loans were given on a promissory note. Promissory notes come under negotiable instruments, which is list 1. Therefore, any law dealing with a loan on negotiable instrument or a promissory note or a hundi can only Parliament can legislate. You can't write off the loan. The state government can't write off. It's a pawnbroker, it's all right. If the fellow has taken money on pledging of jewelry, it's okay. But if it's on promissory note, it can't be, because once a loan is taken on a pro note or a bill of exchange or a hundi, then it is coming under list 1. But what did the court say? There is an entry in the Constitution, says agricultural indebtedness. So, writing off of loans for farmers who are hit by drought is a relief against agricultural indebtedness, a law which grants relief. They said loans of more than 10,000 up to 10,000 rupees are written off for in drought hit districts. The Supreme Court said, what is the pith and substance of this law? The pith and substance of the law is rural indebtedness, agricultural indebtedness. It is not a law relating to negotiable instruments. So there are a number of such things as what is the pith and substance of a particular law. Now we are arguing in this online gaming case, this banning of online gaming in pith and substance is a law of betting and gambling. In pith and substance, it is not a law relating to telecommunications. Let us see what the Supreme Court says. So pith and substance is a very important topic, because you see what happens is very often Parliament makes a law. It may entrench or it may trespass into the state legislating field. See, for example, you ban loans, the state government is banning loans. What they are saying, you can only ban agricultural loan, but if they are dealing with pro notes and bills of exchange, you are trespassing into banking territory, which you can't do that. Similarly, Parliament may make a law and it may trespass into state law. In that case, the courts say, what is the pith and substance? If pith and substance, if it's a central law, central subject, then merely because there is incidental some state subject involved, it doesn't really matter. That's the doctrine of pith and substance. Now the other doctrine, which is very important, is occupied field. Now I come to the concurrent list. Please come to the concurrent list. Concurrent list is a list which contains 66 subjects, actually 64 because last is stamp duty and cess, where both Parliament and legislature can make a law. Both Parliament and state legislature can make a law. So that's why I use concurrent list. That is, union legislature and state legislature can concurrently make laws with regard to a particular subject. Now suppose there is a central law and state law, which will prevail? Central law. Now there what the point is this. Take for example, trade and commerce is entry 26 list 2. But trade and commerce in essential commodities is entry 33 of list 3. Therefore, the Essential Commodities Act 1955 is a parliamentary law. So suppose, of course, now all of you are in a much liberalized economy. When I was a young student, everything was under control. You had milk control order, aluminum control order, ethyl alcohol control, everything was control order. It was called a license permit control Raj in those days. But now most of the things are liberalized. When we built a house in 1974-75, cement was controlled. And 28 rupees was the cement bag. And if you go to the black market, it was sold in 120 rupees. So when we had to build a house, we had to apply for cement, wait for 3 months to get allotment of cement. Then they'll allot only 24 bags. You want 200 bags. Then you bring 24 bags, you build some part of the wall, wait, again wait for some more cement, build house. This is how things are going on in those days. Yes. Of course, there's a very malpractice of the black market thing, yes. But in fact, there's a rumor that most of the houses in Bombay are built from diverted cement from the Indira Gandhi Canal in Rajasthan, because cement would just be diverted. But that was the evil. The moment you have control, there's bound to be malpractice. But what I'm telling you is, essential commodities come under entry 33 of list 3. So, Once Parliament has passed a cement control order, that field becomes occupied. I am talking of doctrine of occupied field. Each legislative entry is a field of legislation. Suppose cement control order is there, then the cement area is occupied by parliamentary law and the state government cannot encroach upon it. Suppose there is something, say cycles. Cycles are not under Essential Commodities Act. Then the state government can legislate. Why? Because it is unoccupied. So in concurrent list, you must first test, is it occupied? Is it not occupied? Suppose it is occupied. There is still a way out for the states. That is called under Article 254, presidential assent. You must have heard of repugnancy, that if a state law is repugnant to the central law, the state law will not take it. To that extent, it will be treated as void. But suppose, for example, the Stamp Act is a central act. Stamp Act 1899 is a central act. Yeah, please. Thanks. All the best. Thanks. Thanks. I'm also finishing. Yeah. The Stamp Act 1899 is a central act. Now, when you go to your college library, take the Stamp Act. Take the CPC. See the Bare Act. You will find below section 100 state amendments. Section 100 will be the main parliamentary law, but Tamil Nadu would have made such a state amendment. Now, that state amendment must get presidential assent. If the state government gets presidential assent, then in that state, that law will prevail. Right? So, this is a way out. For example, we are now matters going on in the Delhi High Court on education. Entry 66 of List 1 enables Parliament to pass laws with regard to coordinating and determining of standards in higher education. Coordination and determination of standards in higher education. In terms of Entry 66, UGC has been formed, University Grants Commission. UGC can say every law school, the dean will be a PhD. Every head of department of constitutional law, tax law must have at least post-graduation in that degree. So UGC can prescribe standards which all states have to follow. Entry 25 of List 3 talks of technical education, medical education, and higher education. Supreme Court has held Parliament's power is only for coordination, determination of standards. The state's power with regard to medical education, unless there is a special parliamentary law, you can't prevent the states from doing it. An interesting case which we argued, this was the first constitution bench case we argued in COVID, and with 46 volumes, Supreme Court had made fantastic arrangements for online, and we had also argued this case for Tamil Nadu Medical Officers Association. I'll tell you what happens. In Tamil Nadu, as you know, there is a very tough competitive exam to get post-graduation, MD, MS, etc. The competition is very severe. Even 1 mark can make a difference. You may not get the postgraduate field of your choice. What Tamil Nadu did was, they had a scheme to encourage doctors to go and practice in rural areas. Today, the best primary health service is in Tamil Nadu, Kerala and Himachal, partly because of this incentive scheme. So a doctor who goes from Chennai, let us say to Nagapattinam, or goes to some Tiruvarambur, some smaller rural area, and works for 3 years, he gets an extra bonus mark of 5 marks or some marks, extra incentive he gets. In the NEET exam, they tried to make Part 9, Para 9 to say that apart from this, no other incentive can be given. So they said no state can give incentive. We challenged it and we succeeded in the Supreme Court. We said, again, in terms of occupied field, entry 66, the Medical Council of India can only set standards for medical education. What is the syllabus? Who are the professors? What is the laboratory requirements? Yes. But how much incentive to give to doctors to practice in rural areas and give them benefit is a state subject. The Tamil Nadu law was upheld. They said it remains an unoccupied field. Parliament's power has not overriding, does not override the state government's power in areas which is not occupied. So similarly, now what we are arguing in the Delhi High Court is coordination determination of standards. UGC has prescribed autonomous regulations. UGC say we'll give autonomy. So tomorrow they will say Shri College will be autonomous. Once it's autonomous, it doesn't have to bother about Delhi University. It can have its own syllabus, own staff, etc. And it will become autonomous. But Delhi University must grant the degree. So we are challenging it by saying determination of standards under entry 66 does not include granting of autonomy, granting of affiliation. That is still coming under the state subject. Granting autonomy is an unoccupied field unless Parliament makes a law saying that UGC will grant autonomy, state's power is unfettered. So this is an example of occupied field. Lastly, I'll come to colorable legislation. The Schedule 7 is very fascinating because, you see, these are all fields of legislation. Parliament can make laws, state can make laws, and you can also make a note that India is a federal, all of us say, right, we are a federal structure. But what the Supreme Court has said very nicely is we are an asymmetric federal government. We are asymmetric federal government because although we are federal, there is a tilt towards the center. It talks of a strong center and relatively weaker power to the state. So it is not completely autonomous like in the US, where the state can virtually tell Trump to do what it likes. He can do. That's the kind of protest will go on. But that's not possible in India because our constitution is framed in such a way that it's a strong center and the states are not that powerful. And it was a conscious decision. If you see the Constituent Assembly debates, Dr. Ambedkar said it was in the wake of the partition, in the wake of all these problems. So they said that we need a strong center. We have got huge issues of divergence in language, you got divergence in culture and so on and so forth. Unless the center is strong, this whole country may not hold together. So we require a strong center. That's why it's called an asymmetric federalism. But one thing you may note as far as Schedule 7 is concerned, and that's why I read the MADA judgment, the Mineral Development Judgment. Please make a note that many entries in the state list will say subject to. Mineral rights are there in the state list. It says taxes on mineral rights subject to law made by Parliament. So what happens is the state government law will become subservient to parliamentary law. So in the legislative entries, you got the words like subject to, other than, subject to declaration made by Parliament. So you got all these subject to laws, other than laws. So the state legislature, many entries also, are not fully independent. Some are subject to state law. Now, this, why I am saying is, 9 judges of Supreme Court have now clarified that states are not subservient to the center. Tax on land and buildings. Entry 49, list 2 is tax on land and buildings. Supreme Court has said tax on land includes tax on the minerals under that land. Earlier the law was, the tax was sought to be levied by the Mines and Minerals Act of Parliament. Supreme Court said that's only royalty, that is not tax. And they have said, since tax on land on building doesn't say subject to, other than, this, that, etc., tax on land, the power of the states is unfettered, it is complete. Right? The legal term is the power is plenary. Plenary power means complete power. So wherever the list, subject in the state list is not constrained by subject to, other than, or other such words, that particular entry must be given its full scope. Now, the other thing Supreme Court clarified was that the states must have fiscal autonomy. This is also, you can make a note, the new development in law in Mohit Minerals and in MADA is fiscal federalism. It is not just legislative federalism, it is also fiscal federalism. Each state has got its own path. It can raise resources for what it wants. Jharkhand may be a more mine-owning state, so it may have laws to develop mines. Bombay, Maharashtra may be more commercial state. They may have tailored laws. Say, for example, Kerala. They may have laws more toward tourism, fishing, sea, etc., like that. So, what they said was fiscal federalism. Each state is autonomous. And if the taxing entries are not subject to, then the states have full power to do what they like. Now I come to colorable legislation. And I'll lastly deal with aspect theory and I'll complete. What is colorable legislation? Yeah, tell me.
What cannot be done directly cannot be done indirectly.
Yes, that's a good explanation. What is colorable is, you make a law appearing to be valid, but actually it is doing something which is prohibited. Like you said, you can't do something directly, therefore you adopt an indirect route to do the same thing. So there are laws which Supreme Court has said is colorable. Of course, not in the context of Schedule 7, but for example, in the DC Vadhva case, ordnance power, you must have heard about the ordnance case, right? Ordnance can be made for 6 months at a time, but if you keep on making ordnance, what is it? It's a colorable exercise of your power. Now, Kerala, what happened? Now, please note, there is requisitioning and acquisition of land. There is requisitioning of land, acquisition of land. Acquisition of land is where the state acquires your property, and in terms of the Land Acquisition Act 1894, has to give compensation to the person for that land. Now, what the Kerala cashew packing, some law, Kerala cashew law, I don't know the full name, what it did was, if they acquire the land, they have to pay compensation, right? So they didn't acquire the land, they requisitioned the land. They said, we can requisition 3 acres of yours and use it for the government purpose. And that requisition could go on for 5 years, 6 years interminably. So Supreme Court said this is a colorable exercise of power. Requisitioning by definition is a temporary phase, wartime requisitioning. During war you want to requisition, all the trucks are requisitioned for using for the war purposes. Or during floods, they can requisition schools premises for housing the homeless people. These are all requisition methods. So Supreme Court said requisitioning is basically temporary. You can't use the requisition power and requisition indefinitely. This is clearly a colorable exercise of your power. Right? Now, last is the aspect theory, which I've been perhaps alone in saying that it's a wrong theory completely, but this is as applied. What is the aspect theory? Now, aspect theory is borrowed from the Canadian Constitution and wrongly applied by the Supreme Court, that is my view. What is the aspect theory? Tax on professions is entry 60 of list 2. Tax on profession is entry 60 of list 2. They levied service tax on profession. So we challenged it. We said if it's an architect, a chartered accountant, a lawyer, these are all professions. Because in income tax, you've got profits and gains from business or profession. Business is where you carry on. Professions, basically, you use your mind power to earn money. As a doctor, as a chartered accountant, as a lawyer, as a management consultant, these are all professions. All of you are professions, because you will be earning your livelihood by exercising your mind, not by making goods or making products. So, your professions. So, we said when tax on profession is there, only states can levy service tax, any kind of tax. Now, there is a law in the Supreme Court which says every legislative entry must be given the widest scope. And the Supreme Court has held in International Tourist Company, please see an entry. You want to see whether this law comes under that entry or not. That entry must be given the widest possible scope. In fact, the court goes to the action by saying, only if this law cannot be brought inside that, it will be excluded. Meaning such a big elastic scope should be given. So I argued that tax on profession includes everything. It can be service tax, it can be a profession tax. But Supreme Court said no. They made aspect theory. They said a profession has two aspects. Once you pass as a lawyer and you decide to practice law, then it's a tax on profession. All of you are practicing the profession of law. But if you choose to actually practice as an advocate, then you are exercising service as a lawyer. And they made this theory that a tax on profession is a tax on becoming a professional, right to be a professional. A doctor, you pass a medical thing, they can pass. But only when you practice as a doctor, you will be levied service tax. I find it bizarre but wrong. But anyway, that is the law of the land. Whatever Supreme Court says is Article 141. As all of you know, Supreme Court is not infallible. What's the law? Supreme Court is final, not because it is infallible. Supreme Court is infallible because it is final. And the US Supreme Court said, if there was a further Supreme Court above the US Supreme Court, 40% of the judgments would be held to be wrong. That's the maxim. So whatever Supreme Court says A plus B is equal to C, it is C. That's all. Why you should not ask. And that's okay in one sense, certain. At least the people know that this is the law. We all can move that way. So now, one other thing of entry, list 1, list 2, list 3 is aspect theory is the law. For example, in motor vehicles tax, they levied service tax on passengers. Supreme Court applied aspect theory. I will levy tax on your passenger bus. It's a tax on the motor vehicle. But when you carry passengers, I'm levying tax on the service aspect of carrying passengers. Therefore, it is applicable. So, a tax can be on a central subject and a state subject. One more matter we lost was leasing. Hire purchase. All of you have got two-wheelers or cars. You must have taken a hire purchase and you pay a EMI, right? Suppose you buy a vehicle, you pay a EMI, equated monthly installment. Now that EMI consists of a principal component and a interest component, right? What do they do? 2 lakh is the vehicle. They add the 36 months interest and divide it by 36. So it has an interest component, a principal component. Now sales tax is levied on the entire EMI. They started levying service tax on leasing transactions. Supreme Court said yes, nothing wrong, because when you sell the vehicle on EMI, you are paying sales tax. But when you take the loan and pay the EMI, it's the financial aspect which is being taxed. So one is the sale aspect, sales tax. When they levy service tax, it is the financial aspect of the vehicle. According to me, it is wrong. Once I buy a vehicle and I pay on the EMI, it's everything. You can't then bring in service tax, etc. So in Schedule 7, I'll conclude by saying you have learned pith and substance, occupied field, colorable legislation, and aspect theory. These are the 3 lists. If you study the list, it is very beautifully structured and they made it very carefully. You take estate duty, entry 85 of list 1. Now agricultural land is state subject. So estate duty other than on agricultural land is central list. Estate duty on agricultural land is coming in the state list. Fishing. Now, there is a very interesting argument. Where does Tamil Nadu end? Does Tamil Nadu go up to 12 miles or not? You got Karnataka border, right? What's territorial waters? 12 miles. Is that part of Karnataka? That question is left open. My argument is no, Karnataka ends at the beach of Karnataka, then India starts, so 12 miles. Now if you go to the entries, fisheries, state subject. Fishing on high seas, central subject. So like that, there are various entries that have been done. Some have been given to the states, some have given, and if you see it carefully, it's so beautifully done, so thoughtfully done, to avoid minimum overlapping. Despite that, cases come, and then we decide the cases. So thank you very much.